Good morning, good afternoon. Greetings from the HKIAC. My name is Joe Liu. I'm the Acting and the Deputy Secretary General of the HKIAC. And I welcome all of you to today's webinar, jointly organized by the HKIAC and the 4 Pump Court. At this webinar, we're pleased to have a panel of experts in Hong Kong and the UK to discuss the UK Supreme Court's recent decision in the high-profile case of Halliburton versus Chubb. The Halliburton decision is said to be the most significant decision on English arbitration law in nearly a decade, and the leading English law case on arbitrator conflicts. The judgment dealt with and clarified a range of interesting and important issues. For example, an arbitrator's legal duty of disclosure under English law and the interplay between that duty and the duty of confidentiality, as well as refining the test for apparent bias, taking into account the characteristics of arbitration and the practices of different fields of arbitration. The court's judgment on these issues is of significance not only to arbitration in the UK, but also to the wider international arbitration community. It is also a decision relevant to the arbitration practice in Hong Kong and to HKIAC. Under Article 11.4 of the 2018 HKIAC rules, an arbitrator has the duty to disclose any circumstances likely to give rise to any justifiable doubts as to the impartiality or independence of the arbitrator. We have also recently updated our arbitrator declaration form to specify the criteria for disclosure under the HKIAC rules, and also to make it clear that soft law instruments issued by any institutions or bodies other than HKIAC may not be identical to the disclosure standards under the HKIAC rules. Hong Kong has also adopted the same standard for apparent bias as that under English law, which is whether an objective, fair-minded, and informed observer, having considered the relevant facts, would conclude that there was a real possibility that the arbitrator was biased. This real possibility test has been applied by HKIAC in determining numerous challenges to arbitrators. The Halliburton judgment provides helpful guidance and clarification on how the test should be applied. We have already seen parties referring to the Halliburton judgment in a recent challenge submitted to the HKIAC. Over the last 10 years, HKIAC has dealt with 28 challenges to arbitrators. 20 of them were rejected, 4 were withdrawn. In 3 cases, the arbitrator resigned before HKIAC's determination, and 1 challenge is pending. HKIAC has given full reasons in its challenge decisions, notwithstanding that it is not required to do so. Our general practice of dealing with challenges to arbitrators is set out in a practice note, which is published on HKIAC's website. With that note, like many of you, I very much look forward to today's discussion on the Halliburton decision and its implications. I'm also intrigued about the title of the discussion, Problem Solved or Problem Created? Without further ado, I will now leave the interesting question to be addressed by our distinguished panel today. Now, it is my pleasure to invite Mr. Christopher Moser, QC, arbitrator at the 4 Pump Court, to moderate the panel discussion. Thank you very much.
Good morning, good afternoon, everybody. Thank you very much, Joe, and our thanks are due to HKIAC for allowing us to put on this presentation today and for arranging the technical side, which I hope I am not tempting fate if I say should be flawless. The title, as Joe has said, is Halliburton and Chubb, Problems Solved or Problems Created. We're very fortunate to have 3 expert speakers on this subject. Those of you who've read the judgment of Lord Hodge and Lady Arden will appreciate that this is a tangled thicket, not a primrose path. Our 3 speakers are firstly Nicholas Vinell, QC, Head of Chambers at 4 Pump Court, a deputy judge of the High Court in England and Wales in the Commercial Court and Technical and Construction Court, with very considerable experience in international commercial arbitration, especially under the rules of the ICC, LCIA, and LMAA. Andrew Stevens, a barrister at 4 Pump Court, whom the Legal 500 ranks as excellent in international commercial arbitration. He has experience as counsel under the rules of numerous institutions in Europe and Asia, including CTAC, SIAC, and of course, HKIAC. Nick and Andrew were counsel for the fourth intervener in the Halliburton case, which was the London Maritime Arbitrators Association, whose acronym is LMAA. So we are lucky to be getting a real insider's view into the proper analysis of this decision and the problems it solves and throws up. We're also very lucky to have secured Queenie Lau of Temple Chambers as our third speaker. She'll be familiar to our Hong Kong audience, or she certainly should be. She's a rising star of the commercial bar in Hong Kong, an accredited mediator, fellow of the Chartered Institute of Arbitrators, and she's on the HKIAC list of arbitrators. The Legal 500 describes her as highly intelligent, great attention to detail, hugely responsive, just a pleasure to deal with. We agree. We have a tight program. Each speaker will make a 10-minute presentation, and then there will be time over for questions. We have a little bit of latitude and may be able to go beyond the 3/4 of an hour allowed for this webinar in the planning. But may I ask that your questions are submitted on the question and answer function on your screen. I will refer to as many of those as I can. If there are any major questions outstanding, which we haven't got round to by the end of the session, we deal with the answers to those subsequently by email so that they are not left unaddressed. We are going to ask you to take part in polling at 2 stages during the presentations, one during Nick's presentation and one at the end, and you will be given a multiple option question on your screen to submit your answers. Nick will start. He will give us an overview of the decision. Andrew will follow, and with particular focus on the effect of the decision for specialist arbitration institutions. And Queenie will address the implications of the decision for the Hong Kong legal and arbitrator community. Without further ado, and 5 minutes late, I must ask Nick to start. Nick.
Well, thank you, Christopher. Thank you, Joe, for your introductions. Good afternoon, everybody. And can I say straight away, I would much rather be in Hong Kong than in cold, wintry London, but let's hope it won't be too long before that happens again. I'm going to take this at quite a canter because I expect all of you will have read at least part of the Halliburton decision, but it's just worth starting off by reminding ourselves of the facts, which I put on my first slide. And whilst that slide is up, let's have the first polling question, which you can be thinking about as I go through the facts. So in terms of the facts, this was a Bermuda form arbitration case. So it's an insurance arbitration on a standard form, but it's essentially ad hoc arbitration arising, of course, out of the Deepwater Horizon disaster. And in the first dispute, the court appointed an arbitrator who we've called on this slide M. That's not actually for Christopher Moger. It wasn't Christopher Moger. It was Ken Rokerson, but we've called the arbitrator M to remind you that Christopher is a full-time arbitrator. And the arbitrator M was appointed by the court, but had been Chubb's choice, had been Chubb's preferred choice as the third, that is to say the chairperson arbitrator. And when M was appointed to the dispute between Halliburton and Chubb, Ken Rokerson, M, disclosed his involvement in prior arbitrations involving Chubb, and neither side took issue with the fact that he'd had previous appointments from one of the parties. So in a sense, absolutely fine so far. So remember that in this case, there was no issue at the time of appointment in terms of the arbitrator's disclosure. But the problem arose from what happened subsequently, because in subsequent arbitrations between Chubb and Transocean, so one common party, Chubb, Ken Rokerson was appointed again by Chubb. And the real point here is that he failed then to disclose to Halliburton the facts of his subsequent repeat appointments by Chubb. So actually, if you want to click on the polling, we're interested in your view as to whether Ken Rokerson ought to have made disclosure of his earlier appointment to his earlier appointees, and given that he didn't, whether he should be removed for failing to do so. Those are obviously the issues in the case. Because what happened is Halliburton found out about the subsequent appointment, asked the arbitrator to resign. He offered to resign, but his appointing party insisted he remain. And so the issues for the Supreme Court were, should he have disclosed when he received the subsequent appointment, and given that he didn't, should he be removed for bias? So we'll look in a minute at your views on those questions, but if we go on to the next slide, let's just quickly review what the court said. In the High Court, Mr. Justice Popplewell, as he then was, said there was no obligation to disclose in this case, and he pointed out that there are benefits of multiple appointments. He said that the particular arbitrator had a reputation for integrity, so that no concerns were raised, and since there was no obligation to disclose, he'd obviously decided that the arbitrator shouldn't be removed. The Court of Appeal took a different view, that there was a legal duty to disclose. They held that duty wasn't breached, however, and therefore the arbitrator wasn't removed. The case went to the Supreme Court with a whole host of interveners, including Andrew and me for the LMAA, and the Supreme Court said, yes, they agreed there was a legal duty to disclose, but they weren't going to remove the arbitrator for apparent bias. Well, I wonder if we can see what answers you gave to those questions before we see. Should the arbitrator have made disclosure? Many people think yes. Should the arbitrator have been removed? Well, that's what you call a score draw, I think. Almost exactly equal numbers, thinking he should have been removed for failing to do so, and quite a lot uncertain. And if I may say so, I think it is the second question which is much the more difficult. And we'll come back later to whether perhaps the answer would be the same if the case were run again. Okay, well, we can close those results. And let's go on to the next slide, because I just wanted to say a little bit about the context of this case before going on just to highlight the key points it decided. First, and obviously, this went to the English courts because the curial court for the arbitration was the commercial court, and then beyond that, the courts of England and Wales. So this is a case about English arbitration practice. And if and insofar as an arbitration is seated elsewhere, there might be different approaches taken by the curial court. It's the first point to make. The second point on the context is that because this was a Bermuda form arbitration, there was no express agreement between the parties about arbitrator disclosure, whether by way of arbitral rules or otherwise. And that's very important, I think, because I think that will tend to be the exception rather than the rule. I mean, Joe highlighted clause 11.4 in the HKIAC rules. Most people arbitrating will have at least something express, either in their appointments or the rules of arbitration, which may affect the Halliburton position. And the third point is that Halliburton is therefore the vanilla English common law position. So let's go on to the next slide and quickly summarize the main legal issues. And before starting on them, we need just to remind ourselves about this creature of the common law, who I've called IFMO. He is the informed, fair-minded observer. He's a little bit like the man on the top of the Clapham omnibus. He doesn't really exist. He's a paragon of virtue. He's not too close to any of the parties. He's not unduly suspicious. And he even knows about the mores and practices of the particular arbitration he's being asked to express a view on. But he is objective. He's not either of the parties. So on the first question, what is the duty of disclosure? The Supreme Court told us that the duty of disclosure is to disclose circumstances which would or might lead IFMO to conclude there was a real possibility of bias. Notice, in a sense, the double contingency there. Would or might reasonably lead IFMO to conclude, not definitely would, just would or might. And the conclusion is a real possibility of bias, not a certainty of bias. So in that formulation, two areas, if you like, subjunctives, two areas of less than certainty. So that's when you've got to disclose. Second question, what is the test for bias or removal of an arbitrator? The Supreme Court said it's exactly the same as the test in relation to a judge. The question is whether IFMO would conclude there was a real possibility of bias. So again, a contingency would conclude, a real possibility of bias, but this time the question is whether IFMO would conclude there was a real possibility of bias. And I put those two tests next to each other because understanding the subtle difference between them is, I think, the key to unlocking what Halliburton says about disclosure. And it explains why there can be a case in which there is an obligation to disclose, but there is not an obligation on the arbitrator to decline the appointment. It's the space between the two tests that allows for that. Finally, though it's not the only other thing they dealt with, confidentiality. What the Supreme Court says is much less clear on confidentiality, but at least I think the following is clear. There are, of course, duties of confidentiality owed by an arbitrator. Those duties of confidentiality cannot excuse a failure to disclose when the test, which we've got on the screen, requires disclosure. And that means that if you are under a duty to disclose, you must either do so or decline or resign the appointment. Whether you can do so depends on what the duty of confidentiality is in the instant case. And that's something which I think we might come back and talk about a little later. So over to Andrew.
Thank you very much. Thank you very much, Nick. Before Andrew starts, we've been asked whether the audience can have access to the slides, and the answer will be yes. Andrew.
Good evening, everybody. There's a lot that can be said about this case, or more precisely about the issue of challenges to arbitrators. And in my experience, challenges to arbitrators are an increasingly common occurrence. Over the last decade, I've seen and occasionally made more and more challenges in both European and Far Eastern seated arbitrations, both under major institutional rules and in ad hoc specialist arbitration. And bluntly, in the most part, the challenges I have seen have been challenges raised most likely, but not always, for tactical reasons or with an eye on thwarting enforcement in jurisdictions where enforcement might be sought. So there's a lot that can be said and needs to be said about the topic of challenges generally, but I only have 10 minutes and I have to talk about one particular case. So my plan is to offer my views on what the title of the event promises. So does the Supreme Court judgment solve any problems? And does the Supreme Court judgment create any problems? But before that, I'm going to start by considering what problems one might say have been avoided by the judgment. If I could have my first slide, please. So does the judgment avoid any problems? You can see that I suggest that two problems have been avoided. The problem of a one-size-fits-all approach in international arbitration and the problem of giving importance to the local reputation of arbitrators. So as to the first, the idea of a one-size-fits-all approach to international arbitration. International commercial arbitration is a broad church, offering a wide spectrum of international disputes with often very different requirements on the part of users. I often refer to it as having at the one end of the spectrum what you might call pure commercial arbitration, often high value, sometimes sensitive and highly confidential, usually institutionally administered. And in those cases, appointment is usually overseen by or even affected by the institution. So under HKIAC rules, of course, the parties designate and HKIAC confirms. LCIA and ICC, they appoint, those institutions appoint the arbitrators and parties can at most nominate. And those institutions vet arbitrators very closely. Doing so takes time and it costs money. But parties contract into that. They probably don't mind, they probably want that in high value and commercially sensitive cases. At the other end of the spectrum, I often think of ad hoc arbitration being at this end. Some areas of ad hoc arbitration are very high volume, such as maritime or commodities arbitration with thousands of appointments a year. And because we're talking about an English judgment, I'm going to pick on an English institution for this, one of the interveners. I'll give the example of the LMAA in London and LMAA terms arbitration, which in 2020 saw over 3,000 appointments. And on average, the LMAA sees more references per year than the combined total of London-seated LCIA and ICC arbitration. So you see it's very high volume. But in terms of value, there can be a significant number of relatively low value cases. And there's a smaller number, but not insignificant, of shipbuilding and offshore and finance disputes, which can be very high value. But as for the bulk of cases, there's often a 1-year time bar. So many arbitrations are commenced just to beat the time bar and never go anywhere. And the parties like to appoint their arbitrator by a very simple email with very little detail because they want it to be quick, cheap, and simple. And an arbitrator may never hear further and may never be asked to do anything further on the case. So it was important, I think, that the Supreme Court didn't make any blanket rules which did not take into account that broad church and the varying needs of parties or users of arbitration. And thankfully, as Nick's already pointed out, the court went one further, one better than that. And IFMO takes into account the particular culture, practices, and field of arbitration when addressing the issues raised in this case. At one point, at the permission to intervene stage, one of the institution's positions was that multiple appointments and overlapping references with only one common party should in effect not be permissible. So if we think about overlapping appointments for a moment, in institutional or pure commercial international arbitration, you rarely have the same arbitrator appointed in overlapping cases with only one common party. And for a long time, the position is or was that under, for example, LCIA and ICC rules, parties can veto consolidation of references, although Article 28(1) of the HKIAC rules is slightly different to that. But in the maritime world, it's seen as a good thing to have consistent decisions from the same arbitrator along a chain of disputes, along a chain of charter parties. So the LMAA terms, the SCMA rules, and HKMAG terms, paragraph 15b, they allow the tribunal an unfettered power to order concurrency and sharing of documents and evidence across references. So Lord Hodge decided that such overlapping appointments are not per se impermissible, but they could be in, say, institutional arbitration where they're not very common. The second issue on the slide, I'll deal with very briefly, the relevance of reputation. The High Court and Court of Appeal, as Nick pointed out, referred to Mr. Rokerson's reputation as a reason not to remove him. I think that was rightly generally criticised by commentators. But because what does a Brazilian exporter of soybeans care if the reputation of an arbitrator in a particular city across the sea is good or not, if that arbitrator should have disclosed something by an objective standard but did not? So the Supreme Court decided, I think rightly, that reputation should be given very little weight on these issues. But the next question, does the judgment create any problems? If I could have the next slide, please. Well, the first thing I've listed is disclosure and record keeping. There is now, for English seated arbitration, at least a legal obligation of disclosure that was hitherto not set out. And practically that gives rise to a need to keep records. Can this be said to be a problem? Was it a problem created by the judgment? Well, I think that the need to keep records or to make disclosure was not something created by the Supreme Court in this case. The IBA guidelines have been around since 2004. Any arbitrator who sits in institutional arbitration has to be able to make disclosure and has been doing so for a long time. And a failure to disclose has arisen in cases well before Halliburton and Chubb. So I don't think it's a problem, if you see it as a problem, created by this judgment. But is record keeping itself a problem? I think practically it might be problematic. Obviously, arbitrators have to keep records, but I think law firms, P&I clubs, insurers, users all need to be keeping good records too. And for, say, for example, a law firm or a P&I club with disjointed offices around the world, it may be difficult to stay on top of record keeping across those offices. So it creates a difficulty of some kind, well, there is a difficulty of some kind, but I'm not sure it's created by this case. Will there be more challenges? Well, yes, I suspect there will be more challenges after this judgment, but not in most cases because of anything in this judgment. As I've already mentioned, I think challenges are a growing area of tactical strife already in international arbitration, but I think the high profile of this decision will alert more and more parties and lawyers to the potential tactical traps and pitfalls, but I don't think that this judgment created that problem. What about issues that the Supreme Court has not dealt with? It's not dealt with, for instance, repeat appointments by the same firm of the same arbitrator in related or unrelated cases. And the same hasn't been dealt with in relation to the same party appointing in unrelated cases, or even the judgment doesn't say what the individual characteristics of each different field of arbitration are or how to prove them. Again, to the extent these are problems, I don't think they're created by the judgment. There were problems existing in the IBA guidelines and its footnotes for some time. What about the issue that the test is objective? Some have criticized that. In short, the parties can contract into whatever level of scrutiny they want. They can incorporate IBA guidelines or institutional rules with subjective standards if they want. Again, I don't see that as a problem and not one created by this case. What about the question of, does the obligation to disclose have no teeth because Mr. Rokerson was not removed? So this might resound with a third of the people who answered the poll saying that he should have been removed. Well, firstly, if you think about contractual law in general, sanctions for breach range from termination of a contract to damages to nominal damages. So the sanction of removal doesn't always have to be automatic, I don't think. And so I don't think there's anything philosophically wrong with this outcome. Secondly, a point that Nick first drew my attention to, in listing the reasons why Mr. Rokerson was not removed, the Supreme Court listed as factor number one that the law was not very clear when Mr. Rokerson had to consider whether or not to make disclosure. Well, now the law is clear. So if the same case on exactly the same facts were to come before the court next year, now that the law is clear, I think, given that the first reason for not removing Mr. Rokerson has fallen away, I think we might see a different outcome. And I have to credit Nick with that point because he first identified and raised it. Does the judgment solve any problems? So my next slide. In short, yes, it wasn't clear whether or not on the exact facts of this case disclosure was required. It is now clear. I anticipate that many arbitrators listening to this webinar may be wondering whether they have always disclosed such subsequent appointments or whether they even thought that they needed to. Well, now it's clear that they need to at least think about this. The next slide, please. So to summarize, Nick spelt out the legal duties. Practically, I think there's going to be more disclosure. You need to keep better records. You need to be conscious of the fields in which you operate. But most of all, tactically, be aware of the topic of challenges, conflicts, and arbitrator selection generally. If you have the merits on your side, try to pick an unobjectional arbitrator as far as possible. And if you're the party with a weak case, think about the tactical opportunities that might present themselves. That's all from me.
Thank you very much, Nick. I beg your pardon. Thank you very much, Andrew. I'll now go straight to Queenie, if I may.
Thank you very much. Now, in discussing the question of apparent bias, the Supreme Court in Halliburton discussed, of course, the English law position, but they also highlighted and had regard to particular features of international arbitration. And for example, the fact that arbitrators come from many jurisdictions and there may be divergent views on what constitutes ethically acceptable conduct. And as we consider this topic of apparent bias, one issue that I have been recently thinking a little bit about is the topic of counsel being in the same chambers as the arbitrator. In short, this is an area where the position under Hong Kong law is perhaps not exactly the same as the position concerning international arbitrations in general. And so that gives rise to the question of how the rules would apply to an international arbitration in the specific context of Hong Kong. Now, in Hong Kong, as in England, barristers are self-employed. And whilst they practice from a set of chambers, they don't practice in partnership. And it isn't at all unusual for members of chambers to be acting against each other in cases. And it is also not unusual for counsel and one or more arbitrators, or indeed a deputy judge in court, to be from the same set of chambers. Now, there is case law on this, the Laker Airways case, in which an English court rejected an application for the removal of an arbitrator on the ground that he was in the same chambers as one side's counsel. It was held that in order to establish that there were doubts concerning impartiality, the party seeking the removal of the arbitrator had to show either that there existed a danger of accidental or improper dissemination of confidential information within chambers, or that there was otherwise a significant risk that the arbitrator may not observe the rule against holding conversations with one party outside the presence of all parties to the arbitration. Those matters couldn't be proved in that case, and it was held that there were not justifiable doubts as to the arbitrator's impartiality. Traditionally in Hong Kong, the test for apparent bias is the same as that in England, focusing on whether there is a reasonable apprehension of bias. And similarly, the Laker Airways case has also been followed in Hong Kong. Now, the interesting point for me is that the Laker Airways position is perhaps not entirely in line with the IBA guidelines on conflict of interest published by the International Bar Association. In the explanation to General Standard 6 in the IBA guidelines, it stated that although barristers' chambers shouldn't be equated with law firms for the purposes of conflicts, and that there is no general standard for barristers' chambers, disclosure may be warranted in view of the relationships among barristers, parties, or counsel. And the guidelines also state that parties should inform a tribunal, the other parties, and also the arbitration institution of the identity of its counsel appearing in the arbitration, as well as of any relationship, including being members of the same barristers' chambers between its counsel and the arbitrator. And insofar as an arbitrator is concerned, the IBA guidelines list the situation of having an arbitrator and another arbitrator or counsel being members of the same chambers as something on the orange list of situations. So the IBA's view is that depending on the facts of a given case, a situation on the orange list may possibly, in the eyes of the parties, give rise to doubts as to the arbitrator's impartiality or independence. And those situations require disclosure by the prospective arbitrator. So what is likely to happen in an international arbitration in the context of Hong Kong if a counsel and an arbitrator are in the same set of chambers? I've had the benefit of discussing this with the HKIAC, and I understand that of the 28 challenges to tribunals since 2011, and 2 of those involved the situation where a party's counsel and an arbitrator were from the same chambers. And I understand that both of those were international arbitrations involving parties of different nationalities. Now, in that first challenge, the claimant's 3 barristers' names first appeared on record in the claimant's statement of claim. But formal disclosure of that fact wasn't formally made until about 3 months later. And the respondent relied purely on the fact of non-disclosure. And the HKIAC decided that that fact did not in itself give rise to any basis for challenging the arbitrator. The respondent later raised an additional allegation, which included the fact that one of the barristers had been a pupil of the arbitrator. So just to pause there, when a person wants to become a barrister in England or in Hong Kong, he or she needs to do pupillage with a barrister who is already qualified and essentially do training with that barrister. And in that case, the HKIAC took the view that this additional ground had been raised too late and was time barred. And the HKIAC was of the view that there were not justifiable doubts as to the impartiality and independence of the arbitrator. So then what would happen if the ground of objection based on a counsel having been a pupil to the arbitrator had been raised in time? Well, the second challenge to the HKIAC did involve such an argument, amongst others. And in that case, the presiding arbitrator was in the same set of chambers as the respondent's 2 barristers in Hong Kong. The claimant complained that one of the respondent's barristers had done pupillage with the presiding arbitrator, and the respondent's barristers and the presiding arbitrator had acted as co-counsel in 4 cases in the past 3 years. And still further, they had been co-presenters at 2 seminars. The HKIAC found that all of those matters, whether taken individually or taken together, would not lead an objective, fair-minded and informed observer to conclude that there was a real possibility that the presiding arbitrator was biased. The HKIAC also took the view that the presiding arbitrator and the respondent's barristers shared a professional relationship typical of barristers in the same set of chambers, and that both parties' counsel were very familiar with that type of professional collaboration. And so the HKIAC rejected that challenge. And then I would just draw to your attention that in contrast to those 2 decisions of the HKIAC, there is also the decision in Hrvatska Elektroprivreda and Republic of Slovenia, where an English Queen's Counsel wasn't allowed to appear at a hearing because he was in the same chambers as the president of the tribunal. And the ruling referred to the English practice that such an arrangement was permissible, but the view was taken that in light of the IBA guidelines, if the Queen's Counsel represented his client before them, the president couldn't continue. And the decision was made to disqualify that QC from appearing. Now, in that regard, some commentators have suggested that that Queen's Counsel had done nothing improper and that excluding him, excluding counsel shouldn't normally be an option. And it was also been pointed out by another commentator that a particular feature of that occasion was that the involvement of that QC had been revealed only very shortly before the hearing. So my own 2 cents is that in Hong Kong, given that the legal community is quite small and we are all very used to appearing against each other and appearing before each other, it makes sense to not be overly militant in preventing arbitrations where a counsel and an arbitrator are from the same set of chambers. And so it seems to me that on this particular question of counsel and arbitrators being in the same chambers, the decision of Halliburton probably won't vastly change the current approach. Having said that, I do think we need to be sensitive to the fact that not all jurisdictions have a similar system of self-employed independent barristers like we do here in Hong Kong and indeed in England. And so from a practical point of view, I tend to prefer myself to err on the side of caution in making disclosures and giving details of the relationship between me as arbitrator and the party's legal representatives, or between me as counsel and the arbitrators. And I do find that taking the initiative to make disclosure and giving a sensible level of detail, and also doing all that in good time, may go a long way towards dispelling any unease that any party may have. So I think that's all from me today. Thank you.
Thank you, Queenie. It may be all from you today. It depends on whether I can nail the question. Well, thank you all three for that gallop across this large scenery. There's one interesting question. Well, there are a number of interesting questions. There's one question I'd like to start with, and it's this. The question is, considering Chubb had the same legal team and M as arbitrator in both arbitrations, did this not give Chubb an unfair advantage over Halliburton, meaning in the first reference? And I wonder, Nick, if you would like to respond to that.
Well, thank you, Christopher. I would like to respond to it because it allows me to get on a particular hobby horse of mine, because anonymous attendee and I think, share a feeling that it's perhaps a pity that more wasn't said in Halliburton about fairness in contradistinction to impartiality. And under the English Arbitration Act, the tribunal's duty is to act fairly and impartially. And I think actually that there's quite a strong case to be made, and it's been made by some very distinguished commentators, that the problem with not disclosing a prior overlapping appointment might be a problem of apparent bias. But even if there's no apparent bias, the fact that one party to the arbitration knows what one of the arbitrators in that arbitration has said about a particular point in the past, but their opponent does not, may make the arbitration unfair. And I've actually been in a position where I have known that my opponent knows what one of the arbitrators, which way one of the arbitrators decided a particular point in the past, but I didn't know that, and I wasn't able to find out. And actually, that felt unfair. I didn't think it gave rise to any question of bias, but I felt it was unfair. So I rather agree that there may be circumstances in which an arbitrator has a duty to disclose, not, or perhaps not just, in order to overcome a risk of bias, but in order to render the proceedings fair.
Well, thank you very much, Nick. May I just follow up on that? The House of Lords went out of their way to identify different times for the considerations of these questions. The time when it was relevant to consider the question of duty to disclose was when the relevant information was known or should have been known. The time when it was considered whether removal was necessary was the time when that judgment was made. Now, would it affect the answer to your question, the answer you've given to the question, that by the time of the decision to remove, it was clear, or might have been clear, that there were no overlapping points between the second and first reference, which could have engaged that unfair advantage you've just described?
I think that's quite difficult, but I think the answer is that because the touchstone here is apparent bias, it's a little unfair to have a sort of ex post facto approach, which says, oh, well, after all, really the issues weren't that much overlapping, so it doesn't matter. I think that's a rather unattractive approach to take.
Thank you very much. We've also had a question from Thomas Piper, what is the practical impact of Halliburton against Chubb, if any, on the interview inquiry process when selecting an arbitrator? For instance, under Halliburton and Chubb, does the scope of the arbitrator's duty to disclose depend on the degree of questions asked? And Andrew has bravely volunteered to respond to this question.
If I may, Christopher, I'm really keen to take the next question from anonymous user, if I could pass it on. But
oh, I see.
Somebody else is willing.
The next question from anonymous user was as to repeat appointments. That question.
Yes, but if you want to stick with your present question and offer it to somebody else, I'm happy for that to happen.
No, let's go to the second question of anonymous. As to repeated appointments or the perceived need for repeat appointments, are there insufficient arbitrators readily available? Isn't this another excuse to increase diversity in these arbitrators?
So that's a really interesting question. And I think that I'd pick up on a couple of the words in the question, actually. One of them is the perceived need for repeat appointments. Yes, there's an element of perception to it, but there are also, in some cases, actual instances of needing to have the same arbitrator. So if you think of the, it may be alien to people in the pure commercial arbitration sphere, but if you think of a shipbuilding context or a charter party chain context, in a shipbuilding context, you could have, let's say, 20 ships ordered, and there are 15 arbitrations that arise out of the 15 different contracts, and all the buyers are SPVs, so you have different parties, to that you don't have commonality of parties all the way down the list of 15. And you wouldn't want 15 different tribunals deciding those 15 cases, essentially between the same buyer and the same builder. So there is often an actual need for repeat appointments. And when you start getting into the question of how many times a year or in 3 years can a firm or a party appoint the same arbitrator, they have an instance of 15 appointments, which in a pure institutional world can sound totally alien, but in certain spheres, it's pretty common, and there's an actual need for it. And the point about there being a small pool, I think in reality, there is a small pool, but it's not a small pool in terms of numbers of people actually available. So let me flesh that out a bit. If you think of shipping lawyers in London and Hong Kong, you have a lot of solicitors, you have a lot of barristers, you have a lot of arbitrators. So the pool is not so small if you can choose any of those to be your arbitrator. Where the pool becomes small is that users have confidence in a small number of arbitrators who receive repeat appointments. That's what the users go to time and time again. And there's a question about, is this an excuse for diversity? That I think that's how the question was worded. I'd say it's an opportunity for diversity. If there is an issue, so going back to Queenie's example of counsel and arbitration from the same chambers, if there's going to be an issue on enforcement in another jurisdiction, although it may be okay in Hong Kong or in London, why make the problem in the jurisdiction where you're going to enforce? So yes, it's an opportunity for diversity, but think tactically, think about enforcement, think about what problems you might create or avoid.
Thank you, Andrew. Queenie, I have a question for you of my own. There's reference to in the judgment of Lord Hodge to the question whether an arbitrator potentially appointed in an arbitration has an obligation to carry out reasonable inquiries about circumstances he or she might disclose, or can rest on what he knows without inquiry. Where are we on that, and what do you advise about that?
It seems to me if one takes a sort of purposive sort of approach to it, it would make sense if one does make reasonable inquiries. It seems to me that would certainly be the safer course. And particularly in order to try and sort of stave off any future sort of challenges or problems arising, it seems to me prudent to undertake that exercise.
Thank you very much. We are slightly overrunning, but I propose to ask a few more questions and then to conduct the poll at about 3 minutes to the hour, if that's all right. I'm making that announcement for the benefit of the 199 people who are still participants. And now I'm going to revive Mr. Piper from the grave. His question is, what is the practical impact of Halliburton against Chubb, if any, on the interview inquiry process when selecting an arbitrator? For instance, under Halliburton and Chubb, does the scope of the arbitrator's duty to disclose depend on the degree of questions asked? Nick, can you help us with this?
Yeah, it's a good question, which is code for saying it's quite a difficult question to answer, but it is a good question. But I would tend to think that the basic answer to that question is no, not least because the duty to disclose is, the Supreme Court tells us, entirely objective, doesn't really depend on what the parties might be interested in or worried about. So I think the starting point is that the duty will be independent of the particular questions asked by one party or the other, and I suppose in particular here the appointing party. But there is an open issue in the Supreme Court on whether the arbitrator's duty includes any duty to inquire, to make inquiries or to make reasonable inquiries. And I can see circumstances in which the questions raised by an appointing party in a way put the arbitrator on notice of a potential problem which he or she might not have been aware of. So maybe the answer is no, but.
Thank you very much. Queenie, on the question of confidentiality, the House of Lords wrestled, some people might think somewhat unclearly, with the duty of seeking consent in certain circumstances from the party whose confidence was potentially breached, and at what circumstances what they called high-level disclosure could be made without the consent of a party affected by the disclosure. Is it safe to treat high-level disclosure as permissible without the consent of the affected party in general commercial arbitration? Or should one read this judgment as confined to the semi-specialist Bermuda form arbitrations, to which Lord Hodge seems to deliberately have limited his decision? Lady Arden appears to have taken a different view. Do you think it's safe to make high-level disclosure without express consent?
It seems to me it may not be the most desirable thing ever, but it may be also what strikes the best balance under difficult circumstances. I mean, on that, I would probably sort of side with Lady Arden on that myself.
Thank you. We have a question from Mr. Stuart Ornstein. Do we expect or have we seen any changes to arbitration agreements as the result of the rise of tactical challenges and or the decision in Chubb? I don't think we're the panel best qualified to answer this question because we don't draft arbitration agreements, and problems only come to us sometime down the track when disputes are ventilated under arbitration agreements, so that I'm not myself conscious of any changes to arbitration agreements as a result of the rise of tactical changes. I'll just ask the others to clear that, but my expectation is that that's a question for the transactional department of an international law firm. have I got the position right so far as our total ignorance of the answer?
Well, I suppose, Christopher.
No, well, Nick has explained.
No. Well, I think there are two things which we might expect to see. There's a very clear hint given by Lord Hodge that if arbitral institutions take the view that the practice in their area is different from what I described as the vanilla common law position, it might be sensible to make that clear in express terms in the rules. So I suspect some thought will be given in some quarters to those issues. I think the other thing which is quite interesting is whether arbitrators will start trying to make express the fact that when they are appointed in arbitration number one, they may in the future need to disclose the following facts about arbitration number one when they are offered a future appointment. And it seems to me that arbitrators might be quite well advised to get that sorted out starting now with all their appointments, so that they don't have this problem of not being clear in the future how much they can say about a past appointment. So maybe we will see some arbitrators responding and say, yeah, I'd love to accept your appointment, but you do understand that in the future I would want to feel able to disclose X, Y, and Z about it.
If I may, Christopher, for 20 seconds, there is a part of the judgment that is potentially slightly chilling for arbitrators and their insurers, in that when the judgment discusses Mr. Erickson's not being removed and the toothlessness potentially of the obligation, the Supreme Court says, well, even if an arbitrator is not removed, but they were in breach, the arbitrator may have to pay the costs of defending the application, or even the costs of the application. And imagine in this case, it went all the way to the Supreme Court. What are the costs of the application? So arbitrators and their insurers might want to think about what terms they might want to have to protect themselves from that risk.
Yes, there are, of course, statutory protections for arbitrators in the absence of dishonesty. And in most institution terms, a similar provision, but the trap for arbitrators arises in ad hoc arbitration, where it's their terms that govern their potential liability, as well as Lord Hodge's words of comfort, which I can't say that I begin to understand, that he doesn't envisage a liability of this sort absent bad faith, notwithstanding the fact there's a duty that would have been breached. Anyway, I'm sorry, we must ask now, if I may, HKIAC to bring up the second set of polling questions and give the audience 30 seconds to answer these questions. And from the answers, we'll know whether you've gathered anything of value in the webinar or not. Can I ask you all to make your answers? And can I ask HKIAC to reveal the answer in about 10 seconds? Well, that is a most interesting response. If I may say so, it shows a commendable attention to the presentations of Andrew and Nick, both of whom addressed the topics expressly, which arise in the majority decision. Thank you all very much for that. It only remains for me to thank the speakers for a tremendously interesting and clear presentation on what I described at the outset as a thicket rather than a primrose path. It remains a thicket, but we can see the path. I'm very grateful to them for the hard work they've put into their presentations. Were you not all on mute, you could applaud, and we will assume that you're showing your appreciation in the usual way. May I also thank HKIAC for managing this and Joe Liu for introducing it, and wish everybody in the East a very enjoyable evening and in the West a very enjoyable day. Thank you very much indeed.